Welcome to everyone that's here today. I'm glad everybody came out to hear about behavioral health here in Sedgwick County, so I appreciate the press being here to report on that. Thank you. So with that, why don't we get started?
All right, sir. We have, well, the good news is there's no agenda review because most of you are out of town next week, so there will not be a meeting. Bad news is we have three topics that all of them are important that we're going to go through. There's a report we'd like to start with regarding mental health facilities in Sedgwick County, and that's going to be Robin and Jen and Wendy are going to kind of tag team that presentation. And then we'll talk about zones of influence, and Dale Miller will lead that discussion. And then finally, we have this small issue of local gaming that we'd like to talk about. I think a couple of commissioners would like to actually take the lead on that. So we'll start off with the mental health discussion. And Robin, are you going to start, or who's starting?
Morning, Robin. Welcome.
Good morning, and thank you so much for the invitation to come speak to you today. Okay, do I control this from here? Okay. Just as an introduction, my name is Robin Shattuck. I'm Vice President for Ascension Via Christi, and I'm the leader for the Behavioral Health Service Line. And this morning, many of you in the room have been familiar with the work that the Mental Health and Substance Abuse Coalition has been doing over really the last 3 years. We came together out of a lot of contention and disagreement early on 3 years ago. And as many good groups do, we did a lot of storming in the beginning, trying to understand what the issues were and how we could come together to collaborate to solve some of those issues for our community and the South Central Kansas area. So what we're going to present today is really a high-level overview of a study that was done by an organization that we contracted with. The company is Catalyst. They're located in the hurricane zone in Durham, North Carolina. We contracted with them to really help us determine from a facilities perspective, a provider perspective, population demographics, growth perspective, and looking at mental health across the United States, what are the needs for our community? So we really have looked at the landscape, what are the things that currently exist. We've looked at our current providers and inpatient beds. We've engaged a lot of community stakeholders in these conversations, and then really looked at what are the things besides facilities that we need. So really, Catalyst came back after a lot of, there were in-depth conversations with stakeholders, one-on-one. There was conversation with a visioning group, which consisted of about 10 organizations locally. And then they looked at national models across the United States to see what other communities have done to really tackle and address the rising behavioral health needs across our nation. And they came back really with 3 levels of project development that we could look at. The basic, which would include right-sizing the existing facilities, and primarily at this point I'm talking about ComCare, Sedgwick County Offender Assessment Program, Substance Abuse Center of Kansas. If we right-sized those facilities, we could meet about a third of the existing need. So if you think about where we are currently, their proposal would look at essentially doubling the space for those 3 programs at this very basic level. In 2016 to 2017, there were about almost 500 patients or clients who were not able to be served because of space constraints. So we know that our existing facilities across the boards don't meet the needs of our community. At the intermediate level and this is level of investment, level of building, level of renovation, we could meet nearly 80% of the needs. We would need to invest in new facilities, in wellness, and wellness is not just a gym. It includes social activities, access to case management, access to resources, really looking at how do we keep people well in this behavioral health space. Incorporation of behavioral health more into the existing primary care facilities in the community, and then a need for housing for violent patients. Currently we have a huge lack of facility across our community and across our state for housing for violent patients and for patients who need very long-term care for behavioral health, because their behavioral health needs simply cannot be managed in the community. And then the long-term goal would be over 90% of the needs could be met, and this would really be a comprehensive facility model which would include co-location of our resources. So when you think about how would we operationalize those three different levels, at that basic, it would be a lot of marketing and education to our community about how to access resources, because access to care oftentimes is a barrier because our members of our community don't know where to go to get the help they need. So a huge marketing campaign to help educate our community. Really, team evaluation. Do we have the right players? Do we have the right disciplines? And how could we enhance that, all the while dealing with a huge trained, skilled mental health worker shortage in our community, in our state, and really, again, nationwide. And then a lot of training to our staff to how would we operationalize this model. At the intermediate level, which is the one that would solve not quite 80%, we would need addition of new services. We would need more emphasis on prevention of mental health and early intervention, because oftentimes in our system right now, because we do not have behavioral health and mental health well integrated into the primary care sites across our city, or the federally qualified health centers across our city. It is integrated in some, but not in all. We really need to be able to identify people who are struggling with mental health issues early on, and then intervene so that it doesn't escalate. And then transportation is an issue. In our decentralized model, transportation within our city and within our county is always a huge, huge barrier. The long-term approach to operationalize that would require, again, addition of new services, and those services being capable of broadening the bandwidth of things that we can have available to our community. And then additional study would be required if we go down that road. So just in this basic response, just to give you some ideas of the options. So these are not, all of these things would have to happen. This is just to give you some idea, again, at a high level. And Catalyst used local, regional, and national building cost estimates for both renovation and new build to come up with these very, very high-level numbers. So one option would be to relocate the call center for CommCare, renovate and refresh the Community Crisis Center and Substance Abuse Center of Kansas, which are co-located with technology upgrades. We could relocate and right-size those services in another location, again, expanding to the size that we need. Another option would be to build something new. So as we go through this, each of their options includes renovate in place, relocate to existing space and remodel, or build brand new. Again, with Sedgwick County Offender Assessment Program, that's scope. Same things. We could do some basic renovations, which would basically just be technology updates or upgrades, expand in place, or build new. And then really one of their recommendations as we go through this study is to consolidate those three services into one location, because then you achieve economies of scale. Just as a simple example, you may not need a receptionist or a person at the front desk at three locations. You could consolidate that into one. So just a really easy to understand kind of option. So that's the basic response. The intermediate response would include building halfway housing. This would be for people coming out of substance abuse or inpatient treatment, some sort of temporary shelter to help get them on their feet, maintain their sobriety. In addition, violent patient housing for both men and women, because that is something that we do not have currently in our community. And then again, that idea of wellness program, either expansion, in place somewhere. We don't currently have that, but that's why you don't see much on there, or really new construction would be primarily the way to go. And then the long-term response would be co-location of those critical resources. As I've mentioned a couple of times, we really have a scatter approach. So we have behavioral health services available in various locations around the community. We have mental health association, kind of on the northeast, kind of more in the middle of town anymore. ComCare kind of downtown. Via Christi has outpatient services south near St. Joe. There are a plethora of outpatient providers just really scattered across the community. And then homeless services who are also kind of scattered. So, and then the multitude of community agencies. Think about a woman who's in treatment, who has children, who needs to apply for WIC, needs to apply for food stamps, needs to apply for a medical card, needs to apply for some housing assistance. Those resources are available, but they are not co-located in one place. So again, there are cost estimates on how that could be accomplished, and the three models across the United States that they really have referenced in their we got back over a 100-page report from them. They've really looked at Bexar County, which is the San Antonio model in Texas, which is probably the most comprehensive model across the United States. There's a facility and an organization in Brighton, Michigan that has done some of this, not to the same scale, and then also Davidson, North Carolina. So those really are the three models that they've looked at for how do you co-locate this. So as we went through the Catalyst engagement to talk to our community about the services, the themes that emerged from all of the participants was access to care. So what's your point of access? Where's the front door, essentially, to behavioral health services in Wichita? Ability to pay is always an issue. The mental health stigma. So as much as many of us who work in behavioral health and mental health services try to combat that stigma, there still is a stigma. I hope at some point having diabetes and having a mental illness are comparable, and people don't judge anyone based on a mental health diagnosis. But in our society today and in our community, we do have that judgment still. Lack of inpatient beds. Really, care coordination emerged as one of the big issues, and the HIPAA restrictions. While I absolutely value and understand each of us' right to privacy and confidentiality of our healthcare information, it makes it very challenging to work across the continuum when a patient goes from the jail to Via Christi Emergency Department, maybe into inpatient care, and then they're going to follow up with ComCare in an outpatient setting. We can't legally share a lot of information. We can share some, but there's a lot of information that we can't share. We also co-sponsored a report that Wichita State did on high utilizers, and we know that we looked at the top 100 high utilizers across our community, and if we had the ability to really case manage across systems, it could make things so much better. But it comes back to HIPAA restrictions, which impacts lacking the continuum of care, and no designated care coordinators, because if you work for one organization, you can't care coordinate patients in all these other organizations. Funding uncertainty. There's a lack of funding that's consistent. So much of the care that is provided is not reimbursed, and because funding sources are not secure, staffing is not secure. And then again, we still have this real siloed approach. One thing that would be fabulous is a shared medical record or a shared behavioral health record, so that we all could communicate with each other about what have you done, what interventions have been tried, and how can we help this human being who's in this state of crisis, and not let rules and laws about access to records become a barrier. And then a huge issue is the lack of long-term care beds. Our state has no long-term care beds. That was done away with several decades ago, and so there's no safety net. And we currently are in a situation where the jails provide a lot of care, and that happens to a huge extent here in Sedgwick County, but it is repeated across our state. So the projected need is that outpatient behavioral health discharges are currently growing at about 1% annually. I mentioned a few minutes ago the provider shortage. This is across our community, state, nationally. Over the next 10 years, it's projected we'll need at least 64 additional mental health providers, 6 of those being psychiatrists, and the average age of the psychiatrist currently practicing in Wichita is 52. So project 10 or 15 years, many of those are going to be retired or nearing retirement age, and that's probably well over half of our psychiatrists. 46 mental health staff. We all the agencies in town really compete and fight for hiring social workers. Master's prepared social workers, even though we do have good programs in our community and we're fortunate to have that, we still are not graduating enough. And then 13 other staff. One of the things that we also worked on was identifying the facility gaps. Some of these gaps in our system would require state policy changes, the mandated booking law, law enforcement officers cannot enter into shelters, and then information sharing, back to the confidentiality issues. And then the funding challenges. Again, we are so dependent on grants, trying to find funding to try something new that's innovative and that's a change that may not work. We think it would work, but it may not work. Finding funding for those innovative change opportunities is a challenge. There's a lot of funding at the national level right now for treating opioids and fighting opioids, but in our community, opioids is not the big issue. Meth is the big issue. And the funding sources for meth are gone. All that money now at a national level has moved to fund opioid programs, and that's not what we need here in Kansas. And then again, and I've mentioned this before, just a need for sustainable funding. When you look at the gaps, they really can fall into those 7 categories. About a third into services, just the need for additional services, resources, and funding. The continuum of care that we need to address so that we can take care of people over this whole continuum, because they don't just receive services in one organization at one point in time. They receive services from many of the players in town. Access to care, going back to that, not knowing where the front door is. Community education, because people still don't know where to go to resource care. Communication between the agencies, and then adequate facilities. So Jen and Wendy are going to present the last part of this.
Good morning. I'm Jennifer Wilson, the Behavioral Health Community Collaborator, and I work alongside Wendy Hummel, and we help direct the work behind the Mental Health and Substance Abuse Coalition. So really, we were glad to have somebody outside of Sedgwick County come in and look what we're doing as far as facilities go, so we can understand gaps and identify some needs as far as mental health and addiction treatment services. So really what we found out is we were at a mental health and addiction treatment facility shortage. We must really increase our capacity and our footprint to meet community need. So we have understood that we've outgrown the capacity for any growth. If you go to our community crisis center today, you'll notice that we're using every bit of square footage in that facility, as well as the other outpatient facilities that we have at ComCare. And we must develop our workforce. We are aligning the national shortage of workforce as far as master's level clinicians and medication treatment providers. The cost is going to depend on the level of response. As Robin mentioned earlier, there's 3 levels of response that this facility study provided. It's the basic, intermediate, and the advanced cost. And through the strategic planning, it's going to depend on the options that the community feels is the need. So we're going to have to look at does our community providers, what are they willing to do? There's going to be gaps we're going to have to come together and speak to the loss between all of the providers. We will need to increase our workforce given the projected needs that we've identified, and the client that we serve are also uninsured or underinsured. That means that they don't have the Medicaid coverage that's required for community-based mental health services. And then, as Robin mentioned several times, the access. They don't understand the front door. It could be the Community Crisis Center. It could be our SAC Detox Center. A lot of people are accessing services initially through the ER. And then the affordability of care, understanding that Medicaid is required in order to get those required community mental health services, the intensive case management services that Robin spoke of. So there's no quick fix. It's going to be an adaptive challenge. That means it's going to take some time in order to get to where we really want to be. And we need to continue to advocate for the state and federal change for Kansas to be part of the Excellence in Mental Health Act. That's the federal, I think Joan can speak to it a little bit more than I can, but it really is expanding the capacity to provide community mental health services. It involves reimbursement rates and allowing people to access behavioral health and addiction treatment services easily and more readily. And then our coalition, we're going to have to focus on the uninsured and underinsured. And Wendy's going to speak to a little bit about the strategic planning process, where we're at, and where this facility study really fits in to the mental health and substance abuse coalition's work. Yep.
Morning, Wendy.
Good morning. Thank you for having us this morning. I'm going to wrap it up and kind of give you an overview of what we've been working on the coalition level for this past year. So the slide says project purpose. So we want to facilitate a strategic planning process. That's what we're undergoing right now for the coalition that defines a vision and a mission for the next 5 years or more. Jen referenced that this is an adaptive challenge, which means it's not going to happen overnight. In fact, when we visited San Antonio, we met with Leon Evans, the person who's responsible for starting Restoration Place and Haven for Hope. He called it a 17-year overnight success. So this is something that we need to be patient with if we want to do it right, because Robin referenced this, and I think Jen did too. We've kind of had this approach of putting Band-Aids on things, and that's not really working for our community. So we want to do this right and get it right and make it the Wichita way, which is what Jen has coined it. Next thing up here articulates a set of values that are going to guide the work of our coalition. So that's one of the things our strategic planning team is working on, values, what we want to guide us as we move forward through this entire process. Establishing common goals and priorities for the next 5 years and beyond. Is based within the context of the overall community for substance abuse, mental health, and homeless needs and services. And this next slide kind of captures that. Our focus, like Jen said, is the uninsured and underinsured. So as you can see in this little diagram here, that intersection between substance abuse, mental health, and homeless. Even though the focus of our coalition isn't primarily homelessness, it's definitely a piece of this. Because those that are suffering from these co-occurring or individually substance abuse and mental health, a lot of those individuals are homeless. So they definitely have to be included in this process. And then building partnerships. This is a very big part of what we're doing. As the planning process continues, we are going to continue to meet with stakeholders. Jen and I spend a lot of time meeting with different treatment providers, community organizations, and coalitions, because there's so much good work that's already being done in the community that we really don't have an idea on. There's so many things that are going on, like Jen mentioned, silos. And Tammy Bradley, who's a member of our strategic planning team, says we need to take a sledgehammer to slash down the silos. And I think that's a really good way to explain it, because we really need to come together in this process. Second thing, building an understanding of current efforts and how it relates to the coalition's work. I think I just referenced that. Developing relationships will take time in order to break these silos down. So just to give you an idea where we're at, we're wrapping up the strategic planning process. We're going to have a board retreat, review all of the research that our strategic planning team has done, which includes this Catalyst facility study that you've got Robin's presentation on, the high utilizer study, focus group data. We conducted several focus groups during the strategic planning process, law enforcement data. There's a state mental health report. All of that has gone into the strategic planning process and much more. And then by the end of September, we're going to have a final summit to present the strategic planning process and the results to the stakeholders. Thank you.
Thank you. Well, first of all, I want to thank Robin and Jen and Wendy for being here to bring us up to date on what's going on. Several of us have already been down to San Antonio. I've met with Leon Evans a couple times myself. We put this on our legislative agenda last year as the number one issue on our legislative agenda. We got the city of Wichita on board with us as their number one issue. We got the Chamber of Commerce involved in this. This is a critical issue for Sedgwick County. We need to find solutions to this, and I appreciate that we're going through it step by step, and we're developing our strategic plan, because that's the first thing we have to have, is we need to have a roadmap, as if you don't know where you're going any direction, it doesn't make any difference. So having this roadmap is critical to what we're doing. I know we've got the city-to-city tour coming up in the very near future. A number of us are going on. I think all the commissioners are going on the trip to San Antonio. And one of the major things we're going to be able to do when we're down there again is to have time to go over and take a look at what San Antonio is doing in their facility. So I believe that this will probably still be our number one issue on the upcoming legislative agenda as we move forward with that. The cost of doing nothing is enormous. And so right now, what we're spending is really hidden in a whole bunch of pockets. And that's what we've got to get out to the public so that they understand what the cost is right now to us and what we need to do to treat this. The costs currently, our police department, our sheriff's office, especially our jail for the sheriff's office, our ComCare, our health department, all of our first responders, our DA, our judges. Everybody is involved in this right now. It's just that right now it's divided up and we don't know what the total cost is because we haven't gotten down and drilled down to see what each one of these different pockets are spending. But when we do drill down, what I'm sure that we'll find the public is going to be amazed at what it's costing us today. And we're doing, we're paddling as hard as we can underwater. It's just that when you're above water like a duck, you don't really see that movement. So we need to start seeing that movement above the surface of the water. So anyway, commissioners, does anyone have any questions? We've got,
please.
Commissioner Mites here.
Robin, you made reference to, have a lot of questions, but I'll just ask one that's pertinent. You made a reference to the complications of the HIPAA rules. Mm-hmm. On departments not able to communicate. Since this is a kind of a nationwide issue anyway, I assume this HIPAA conflict has come around nationally. So my question is there a movement among the federal law, the federal HIPAA law, to adjust, to allow a better care for everybody if they can exchange information? Or is that HIPAA dead on arrival?
I do not know of any federal work going on to try to change those rules. In fact, it seems to me like the privacy rules get strengthened rather than weakened.
Okay.
I think there will need to be some creative work on how we can do that. As an example, we have just started a pilot between Via Christi Behavioral Health Hospital and USD 259 so that we can work together and have one case manager that crosses borders.
Okay.
And it took the two legal departments about 2 months to come up with a way we can do releases of information so we can but work within the
rules,
the education confidentiality rules and the healthcare rules. So I think it will take I think that one issue is going to take a lot of work. And I don't have the answer for it right now.
Right. So it's more of an interdepartmental, inter-services.
Right now it certainly
services,
is. And I don't know
out.
if at any point on a state or national level that will change. But it is a barrier.
Yeah, I can see why. Yeah. Thanks.
Mm-hmm.
Other questions?
I have a question. On the long-term response page, you have, it says the Greenfield site. What is that?
New build. Brand new build.
Okay.
Is it named after someone or?
Yeah, like, is that
That
just
is,
what the name is?
That is a construction term, I think.
Okay.
Brand new land, nothing's there.
Okay.
We're not tearing something down. We're going to build. We're going to build from scratch, from the ground up.
Okay.
Very good. Well, I don't see any other questions right now. We appreciate you bringing us up to speed. I hope the press picks up this is our number one issue. This is why it's number one being discussed today. And please keep this in mind as you're reporting, because this is much more important than anything else we're going to discuss today.
Thank you.
Okay, Commissioners, the next topic we'll talk about the zone of influence. You want this over there, Dale? You want the podium? Okay, very good.
Commissioners, I'll run through this relatively briefly. The the report's probably longer than it needed to be, but it's something I'd prepared a long time ago, and so just reusing it. But state law allows cities in Kansas to exercise what's known as extraterritorial zoning for up to 3 miles outside of their city limits, provided the county has not instituted zoning in that same territory. And so prior to 1985, when the county adopted countywide zoning, this is a map of all the different zoning jurisdictions that existed in Sedgwick County. Some of them are extraterritorial zoning authority. Some of it is township zoning. And so it's just a hodgepodge, but I believe there are somewhere in here, I think there's 17 different sets of regulations that if you were a builder trying to work in the county, that you would have to have negotiated under this original situation. Then in 1985, the county adopted countywide zoning, and as part of that process, county staff, now I wasn't here then, but I'm getting this all from memos that I found in the files, that county staff met with all of the cities in Sedgwick County and worked with them to come up with what was called zoning area of influence. And when the county adopted countywide zoning, there was a special section in there that created and established zoning area of influence and adopted this map. And you can see the different geographies that are in play here. And like I said, the staff worked with each one of the cities to come up with the boundaries. And as you can see there, Mays basically only took a mile outside of their city limits, whereas Mount Hope and Cheney and Garden Plain, some of those took the full 3 miles. And so there were different sizes. And of course, like Park City and Keachai and Bel Air, where they had were in close proximity to each other, they went halfway and split the difference and provided the zoning area of influence. And then the crosshatch was that if there was an application, say in Keachai's zoning area of influence in that crosshatch area, then we would notify Bel Air as a courtesy, and vice versa. If there was a case in the crosshatching that was for Bel Air, we'd do the same for Keachai. And so we used these boundaries. The significant thing about this process was that we had to call the second or third class city, ask them if they wanted to hear it. If they said yes, then it couldn't go to the planning commission, the case, until that city had heard the zoning case. And as you're probably aware, most of these cities don't meet, but their planning commissions don't meet but once a month. And so if you happen to have a filing deadline that came right after the city had their planning commission, then an application could be delayed up to a month longer than normal to get it to that city's planning commission. The other thing was that if they recommended denial, then the county commission could only overturn or override that denial with a unanimous vote. And based on what I could find in memory, that's only happened 4 times. So if you were an applicant and you got a denial from a small city, that was pretty much a kiss of death for your application. Then in 1995, there were a number of cities that wanted to expand their zoning area of influence, and there was opposition. Primarily the opposition comes from the development community and builders who have to deal with the myriad of different regulations that were in place, and that, like I said, if they didn't meet and you had to delay it for 3 weeks or 4 weeks till their planning commission met, and I personally won't name the city, I had to go to their planning commission 3 different times to get a case approved because for some reason they just could not make up their minds. My personal opinion was two of the meetings had to do with they just couldn't bring themselves to vote against significant neighborhood opposition, but they wanted to approve it. And so it took 3 trips out there to get this one case, had to do with an airstrip, approved. But anyway, some of the cities wanted to expand their area of influence. As you can see there, Mays went from the 1 mile to this larger geography. Everybody else was denied by the County Commission, the expansion. But what they said was, we'll do this informal notice, so that the dark gray areas where it says informal notice area for Clearwater, Keachai, and Sedgwick. And for example, you can see here, Sedgwick was wanting to expand their zoning area of influence east of I-135. And so instead of approving that, the commission kind of did the Solomon-like thing and said, okay, we're not going to trigger the full process, but we will require staff to send you a notice anytime there's a zoning application in these informal notice areas. And you can see Mulvane got a little piece down below on the southern boundary of Sedgwick County. And so we worked with those. Then in 2007, the informal notice areas were eliminated, and some of the boundaries of some of the other cities were modified, and I won't go through all of them, but some of them were just kind of tweaks. But to a significant degree, some of these tweaks had to do with annexations, and so the boundaries were modified to those boundaries. And then in 17, I believe it was, is the whole process was reconsidered, and it was decided to, instead of using the arbitrary boundaries that were created in 85, the zoning area of influence was renamed urban area of influence, and the boundaries were then dictated by the projected growth area based on work that was done with the communities, with their comprehensive plan, and with the county's comprehensive plan. And so in staff's opinion, these boundaries are more realistic in terms of what is projected to actually happen in terms of a city's ability to extend services into an area than the original, let's just sit down and we want 3 miles, whether we can serve it or not kind of thing, is what it appeared happened in 1985. And so they were renamed from zoning area of influence to urban area of influence. And the other significant change was they eliminated the unanimous vote requirement to override a city's planning commission's recommendation for denial. It is now takes a 4 out of 5 on the first hearing, and then on the second hearing, it can be approved with a simple majority. So it eliminated the unanimous vote requirement entirely with the current process. Let's see here, and I didn't get it included in the PowerPoint, but at the back of the staff report on the very last page, I had Stephen do a comparison of the original square miles that were included in the zoning area of influence compared to the urban area of influence. And so the difference on the right-hand side shows whether it was a plus or whether it's an increase or a decrease in the area. And you can see most of the cities, when we went to the urban area of influence, that geography decreased, although there were 5 of them, I think, that increased somewhat. So that's kind of the quick and dirty version. Try and answer questions.
Well, let me let everyone know why I asked Dale to bring this to you all. I did serve on the MAPC in 2017 when this came up. And there have been some concerns at that time, and still concerns by some of the communities. If you look at the community investment plans, the latest document that was just put out for us to take a look at, you'll see where the projected growth areas are of the different communities in our county. And these communities do have a vested interest in that. And as a matter of fact, say that an obnoxious type of a facility was going to be built just outside the urban area of influence, the communities would not have any impact, any way of impacting that, and it would stifle the growth in those areas. So all I'm asking is for planning department to go back and to take a look at this one more time. I understand that there's some concerns about delay in hearing, and if that's the case, maybe we can write something in there that forces them to have a hearing so that we don't delay developers' hearing at some point. So that could be added to the verbiage. I have no problem with us getting rid of the unanimous vote that was required. Remember, the final decision for all of this comes before the Board of County Commissioners, but I think we have a responsibility to allow the communities that are growing out there to at least express their opinion on some type of impediment that might happen to their growth. So what I'm asking the commission is to go back and ask the Metropolitan Area Planning Department to take a look at this one more time, make sure that they're the right size. I think 3 miles is way too much. I think some of the things that we put in the 2017 is too little. And maybe there need to be some other items added so that you're not delaying your hearings, so that it's not continuing on and on. And overturning the unanimous vote, as I said, I don't have a problem with that. But I do believe we need to review it. I've had communities ask for it. When I sat on this in 2017, we had almost every single community involved in this. Almost every single community spoke against what was happening, so I want to make sure that we hear their voices as we move forward in this. So what I'm asking the commission to do is say it's okay for the planning department to review this.
I'd like to make a couple comments, please.
Sure.
So the proposal initially in 2017, maybe it was even earlier than that, maybe 2016, I don't know when it started, but was to eliminate zoning area of influence entirely.
Yes.
And that got quite a lot of response, and I understand that. I think we reached a compromise, and I actually had people who complimented the commission for being rational and thoughtful and balanced in where we ended up. And I think along with this, Director Miller, I don't know that you've described this yet, but I think we increased our notification response. In other words, as we sit right now, we notify cities of issues that maybe it wasn't. They don't have a binding responsibility to make a decision that the MAPC would be waiting on. But we do notify them of things that happen in the community, and we invite them to issue, if you will, an opinion. And if they request us, we are allowed to we go out there and present to them at their request, even if they don't have a binding vote. In other words, it may not be inside the zoning area of influence, but they can still issue an opinion. So that's, I think.
No, only if they're inside the urban area of influence. Now, the one thing that we did do, and we probably wouldn't need to mess with that, is as part of the urban area of influence in eliminating the unanimous vote requirement, what we now do is we call the city if it's inside the boundary. If it is not inside the boundary, we do not contact them. But if it's inside the boundary, we contact them. They have to tell us yes or no. And if they decide that they want to hear it, they have 30 days from the time we have emailed them to have the hearing. And if they don't have the hearing within, then we proceed, send it to Planning Commission, and it just moves on. They could go ahead and have their hearing after the fact and provide that to the commission if it's a zone change as part of the commission's consideration. But I guess what I would say is if we proceed with reviewing it, I think leaving the process in place works very well, and we would just, if that's the will of the commission, look at the geography, but leave the process in place.
I would just say also, this is one of those things where I think the developers and builders were very pleased with our addressing this.
Yes.
They felt like it was a very clunky system, and slowed the process way down. We actually gave, if you will, in fact, I can't think of anything else. I'll ask our legal perhaps. What other vote do we have at the time? What other vote did we ever have that required a unanimous decision of the county commission?
None.
There was never anything that I know of.
Right.
And so that seemed like a very reasonable change. And then, of course, we have this declining from a supermajority to a simple majority. You know, if it comes back to us a second time, that seems reasonable. That I think everybody understands that very much. There was also this issue of some people were miles from a city, maybe even a small city, but the city would have, if you will, more authority or more determining powers than the county commission, and yet they weren't allowed to vote, if you will, for the representatives making those decisions. It was the cities, if you will, were making decisions that would impact people's right to use their property rights issues. In my opinion, I always look at the Constitution. I think about property rights and based on constitutional rights. And the people that were making these decisions were not elected by them. They were be elected by people inside of a smaller jurisdiction, so they had no control on who was making these decisions. And so it came down to a issue of representation, and that was discussed a lot in that time frame. So there's a lot of reasons why we had the discussion, and I think we ended up, in my opinion, a very balanced thing. I understand when you move the line away from the city's power, they were going to oppose that. I understand that, but again, at the end of the day, I actually received compliments and appreciation from many of the cities that were very concerned about losing their rights altogether. They thought that we ended up in a very balanced position. So again, if we're going to address this today or address it in the near future, I'd like to first of all ask: has there been any problems in the last several years that this has caused? Is there any examples out there that says a city wanted to issue an opinion or wanted to influence something that caused this to go the way they were very unhappy about? To me, that would be a reason why we might want to go back and look at this. But I'm not aware of anything like that.
I'm not aware of anything. Yeah, and the one thing I would add, although it just went out of my head, it'll have to come back.
Well, with that, again, when we make changes in government, it should be driven for a reason. And I guess right now, this feels like sore apples. We're just going back and touching things we touched before because there's still people who are upset about maybe losing their voice a little bit in 17. But at the end of the day, there's not a problem right now. So I think we ended up, I'll just say it again, very balanced, very thoughtful, reasonable place to be. And I love the changes we made because I think we listened to the people and we listened to the cities, we listened to the builders and developers, and ended up with a very balanced position. And I understand from the city's perspective, they didn't like the change. I understand that. But I think where we are today is really a good position still, and I'll still defend that. Thank you, Chairman.
What I would add is, I remembered, is Stephen goes out once, he contacts the cities once a year, and they discuss their growth patterns and what their needs are. And so we're in contact with all 17 cities that have area of influence every year and work with them to try and accommodate whatever their concerns are, but we do that on an annual basis.
Mr. Chairman, one other comment. I would say also, if they want to have an increased geographic space for notification and a right, if you will, to weigh in on something, but maybe not have a binding vote, I'm fine with that. If that's the issue, as long as they do it in a very timely fashion, I don't mind trying to notify someone something maybe a mile outside the zoning area or the urban area of influence, and invite them, if you will, to have a discussion and issue, if you will, an opinion of the city that we can look at, much like a DAB board would or something like this. It's not binding, but it would be certainly taken into consideration as MAPC makes their decisions and as the county commission makes their decisions. I think that's a reasonable tweak if that would make someone happier. And I thought that's where we ended up, and I apologize for not understanding that or remembering the details there, but we did discuss that in 2017. And I think that would be a reasonable tweak to this process if that's what we wanted to do. Thank you.
Commissioner O'Donnell.
Thank you, Mr. Chair. Yes, I absolutely support us reopening this negotiation and talk to the cities that maybe feel like there wasn't a lot of discussion or things were forced a couple years ago, or a few years ago. But I think having the discussion is valuable. I know currently in my district there's a pretty contentious zoning issue on that group home, and the Hayesville, I know, appreciated having a voice in that process, and It's barely inside their zone, but they know that because of their, whether it's their schools or some of their other resources, their police maybe, that will be affected. They're very grateful to have that. But if it was just a little bit further, it wouldn't have been there. And I will note on that issue in particular, it was their zoning board. It was unanimous in opposition to that group home. So I think those are important factors that we need to continue to think about as we make the decisions. As like the chairman said, we're the final decision maker in that process. But it's vital that we get as much input from our communities as possible. So I support at least having this discussion. So thank you.
Thank you. Any other comments? If it's all right with the board, I'd like to ask the MAPD to go back and review this a little bit and come back with some recommendations.
I agree.
Thank you. All right. I guess,
Mike,
Mr. Papoon, you have a comment?
Certainly, Mr. Chairman. Mike Papoon, Interim County Councilor. Obviously, the next item on the manager's list of things to discuss today was the issue relating to the resolution that's on the County Commission agenda tomorrow. I might give a brief history of this before we have, I'm sure, a couple of commissioners that want to weigh in on this as well. I was approached by a couple of county commissioners a while back to look at the issue of having a revote in Sedgwick County on the issue of whether or not we should have slots at pari-mutuel track or electronic gaming machines, as the law refers to them. By way of history, the Kansas Expanded Lottery Act became effective on April 19th in 2007. And as part of that act, they allowed casinos in 4 different zones in the state, and it also provided for electronic gaming machines at certain pari-mutuel locations in the state. The controlling statute today is KSA 74-8743. Back then it was Senate Bill 66. But the controlling statute basically indicated that in those counties where there's a pari-mutuel licensee location, and if you remember, we had the Wichita Greyhound Park operating back in 2007. In those counties where there's a pari-mutuel licensee location, within 180 days of the passage of this act, there had to be called by the county commissioners a special election to determine the question of shall the Kansas Lottery be authorized to place electronic gaming machines in blank county. And obviously the proposition that went to the voters said whether that or not these gaming machines should be placed in Sedgwick County. In my opinion, one of the issues that we've run into is this legislation is very poorly written. The question that went to the voters was that the question I just read, which is whether the slots or electronic gaming machines should be placed in the county. But the very next section of the statute says that if a majority of the votes cast in such an election are in favor of the placement of these machines, then the Kansas Lottery may place and operate electronic gaming machines at a pari-mutuel licensee facility in the county. So all along the statute basically only provided that these machines be placed at a pari-mutuel licensee location, but the voters that went to the polls at that particular time were voting on whether or not they should be placed in the county with no restriction on where these machines would be. So I think that was a problem that the legislature had at that point in drafting this bill. On August 7th, 2007, there was an election held in the county, special election, and at that time, the question we just read lost by a total of 246 votes, percentage of 50.12% to 49.88%, in an election where 101,633 Sedgwick County voters went to the polls. In talking with our election commissioner, Tabitha Lehman, she had determined that kind of turnout for a special election was probably similar to what a presidential primary election would have for a turnout. So obviously there was a considerable amount of interest in our community in that election, but as I said, the vote failed, and as such, slot machines were not allowed at the pari-mutuel facility in our county. In 2010, 3 years later, the state entered into contracts with the various casinos in the state, including the Kansas Star Casino in the South Central zone. As part of that contract, paragraph 30, it prohibited the state from allowing for designated additional areas in the state for gaming. But in the same paragraph, it allowed it in these contracts with the casinos, it allowed for 2,800 machines at pari-mutuel licensee locations in the state. Also following that election, there were several attempts by Mr. Ruffin. Obviously, Wichita Greyhound Park closed shortly after the election. Mr. Ruffin lobbied the legislature for a number of years to try and get a revote in Sedgwick County on the issue of whether or not there should be electronic gaming machines at a pari-mutuel facility. Finally, in 2016, when House Bill 2537 had been brought to the legislature, which was another bill authorizing a revote, Representative Mark Kars asked the Attorney General at that time for an opinion on what effect this bill would have on these contracts they have with the various casinos. And in Attorney General opinion, 2016-6, the Attorney General looked at the contracts and determined that if the legislature were to pass a revote of slots and allow slots at the pari-mutuel facilities, this could trigger this language of a designated additional area, which could turn out being in violation of the state's contract with the Kansas Star Casino and end up triggering a return of a $25 million privilege fee, which the larger casinos had to pay at that time, plus 10% interest from year 2010 to whenever this violation occur, which of course would be a substantial penalty upon, in addition to the $25 million return by the state of that privilege fee. You can imagine after the Attorney General issued this opinion, which frankly it's neither here nor there, but I don't particularly agree with the nature of the opinion, because it was clear in these contracts that 2,800 gaming machines were being allowed at pari-mutuel facilities in the state, and that wasn't a trigger for a violation of the contract. But nevertheless, Attorney General Derek Schmidt issued this opinion, and this created a situation for the legislature that they weren't at that time interested in revoting or having a revote on this issue in Sedgwick County for the fear of perhaps triggering this penalty and causing the state to incur this additional financial liability. So essentially since that time, there hasn't been any movement in this area, hasn't been very much attention brought to this issue at all, and I've been asked by a couple commissioners to draft a resolution authorizing a revote, which I've done, and that's where we are today, and pretty much let the commissioners discuss this from here on out.
Questions of our attorney?
Mr. Chairman, I have one question. Would it be reasonable for us to, obviously there's a renewed interest by commissioners here, would it be reasonable for the legislature to act before we act? In other words, as a non-binding resolution, if I understand that's the right phrase here, why would we pass a non-binding resolution? It seems like the legislature should address this first at the request of maybe one or two commissioners that would be interested in this, but I don't see why we would do this before the legislature would address the same reasons they maybe didn't go down this path before. Has anything changed? I would like to ask the legislature essentially to act before we would act. It seems like we have this backwards potentially.
Those are some good points, Commissioner Howell. the resolution that's been drafted isn't drafted in the form of an advisory resolution. An advisory resolution could be drafted requesting the legislature do something, but this is a resolution asking for a vote at the general election in this November during the mayoral race, and it's not treated as an advisory election. It's one of the issues that we have to deal with in this matter, whether or not that resolution would be interpreted as an advisory, creating an advisory election.
In the past, you and I have talked about some different topics, and it's always an interesting thing to go to ask the voters for their opinion on an issue. And you've told me in the past we're not allowed to ask an advisory question about, it doesn't do anything, simply just polling the people. We can't stick questions like that on the ballot. So I'm curious why is this different?
It would be what a court would interpret this resolution to, whether it would interpret this resolution as being an advisory election pursuant to the statute that I cited earlier, KSA 74-8743. If the court determined that in effect it was advisory, you're right. An advisory election cannot be held at the same time as a general election. The county can have advisory elections pursuant to its home rule, Kansas home rule, county home rule powers.
Let me ask you one direct question. If we pass this resolution tomorrow, will we get sued by the state of Kansas?
I have provided we met with the Attorney General on this issue, and I have provided the Attorney General and his deputy last week with copies of this resolution, indicated to them the action that would be taking place tomorrow's meeting, and I haven't heard back from the Attorney General what type of action will be taken.
Okay, then I'll ask you directly. As an attorney, do you believe we'll be sued if we take action on this tomorrow?
You can never know what will happen in a matter. Mr. Chairman, I would say that there's probably a reasonable chance that there'll be a lawsuit either by the Attorney General or by one of the casinos, Kansas Star Casino. But I have not heard or gotten any indication or feedback from any of these parties that they intend to sue us if we took this action.
So if we're sued, who's going to pay for that lawsuit?
Well, if we're sued, we had pretty much determined that we would handle this in-house. Now that obviously you fund a legal department and nothing's done for free, but we would handle it in-house. We wouldn't use outside legal counsel to defend the suit.
Even if you handle it in-house, we're still paying all of you, your attorneys, and you a salary. So it's still going to cost Sedgwick County taxpayers some money, isn't it?
That's what we're paid to do. But yes, you fund us, and if our resources are used in that direction, the Sedgwick County taxpayers are used to defend that suit.
Okay. What about the Attorney General? If they sue us, who's going to pay for that?
We would handle that law. We would handle that lawsuit in-house.
No, I'm talking about the Attorney General for the state of Kansas. Who's going to pay for their salaries and for their attorneys?
The taxpayers of the state of Kansas fund the Attorney General.
Taxpayers of the state of Kansas. So we've got the taxpayers of the state of Kansas, and the taxpayers in Sedgwick County are going to bear the brunt of all of this, correct?
If a lawsuit occurs, that's a reasonable interpretation, yes, sir.
And I assume that a lawsuit will occur. To the best of my knowledge, that there's nothing in that act that provides us an opportunity to have a revote.
That would be the interpretation that would be up for a court to interpret, but there are several aspects of that act that some challenges to having a revote without some legislation or some litigation.
Okay. Well, I've made it plain a number of times that my concern is that we're going to take Sedgwick County taxpayers' funding, and we're going to pay for a lawsuit that we're not going to win. And we're going to take the state of Kansas taxpayers' money, and we're going to fight a lawsuit against us. And at the end, who are going to be the winners and losers? It's certainly not going to be the taxpayers in either Kansas or Sedgwick County.
Mr. Chairman, I think there's also another risk that the legislature might go for it, and if that happened, I think there's going to be other lawsuits by Kansas Star Casino, Boyd Gaming against the state of Kansas and against the county. That's another possibility. And with that, one of my questions is, we talked about the $25 million privilege fee plus 10% interest. Has anybody calculated what that would be in terms of 2019 or 2020 dollars? I would assume it's above $30 million. I don't know what that would be. I have not calculated that. Do we have a number that we're talking about? I'll just tell you, I had someone contact me over the weekend. They're saying that apparently the legislature had the same question last time they discussed it, and I assume it was legislative research, but they estimate it's not just the Kansas Star. It's all of the casinos potentially would have a lawsuit, and the total cost they estimate would be $130 million. So again, I think there's a lot of questions about what is their actual risk. I don't know. Should the lawsuit go in that direction? Is there also damages potentially that are payable to these casinos for lost revenue potentially? If you add that in there, that could be significantly even more than that. So I guess we need to have a good fiscal estimate on what would happen potentially if we lost this lawsuit in terms of legal costs and privilege fee repayments and to me that there's a lot of information about this we just don't know.
I have a quick question. Could you talk briefly about disorderly election conduct?
Yes, Commissioner Cruz. One of the issues that we've been looking at as part of this process is what effect, if this would be determined to be an advisory election, what effect that would have on the election commissioner, and whether or not that would be a violation of a statute involving disorderly election conduct. The AG, the Attorney General's office, has way back in 1994 indicated that we're entitled to have advisory elections through our home rule authority, but those have to be conducted by the county and outside of the general elections, and the election commissioner is not required to be involved in an advisory election. That's an election that would be conducted entirely by the county and county staff outside of the election commissioner process. If we were deemed that this was an advisory election and the election commissioner participated in this, there's a chance that somebody could determine that she was engaging in disorderly election conduct. Now, there's an intent process there, criminal intent process that would have to come, and I don't think that would be probably a very difficult hurdle to achieve for a district attorney when you have an election commissioner that's following the will of the county commission. But in any event, that's there, and it's a concern that we're looking at, and we're getting it. If this were to pass, we would have separate counsel for the election commissioner so that she would be fully advised on how to proceed in this matter. Because our office represents Tabitha as well as other department heads, other elected officials, and of course, primarily you.
So this would be considered an advisory election?
This could be considered an advisory election.
Okay. And we can conduct advisory elections, just not during a general election?
Right. It'd have to be a special election, which could be in concert with or not in concert with the county election commissioner. In the past, and she can speak for herself, but in the past, I think Tabitha has indicated that she does not intend to conduct advisory elections through her office. So.
But the intent of the or the ballot initiative tomorrow is not an advisory election ballot initiative. It's a binding election.
That's the point of the resolution,
right,
Commissioner? Yes.
Mr. Chairman, I don't understand the comment that was just made. What do you mean it's a binding resolution? What is that? What do you mean by that? Nothing.
It's a vote. It's a vote by the people to say they want to allow at a electronic gaming machines at pari-mutuel facilities.
But,
that's what it is.
So are you saying then at that point we can go ahead and place the machines at the Greyhound Park and that?
No, the county doesn't, and the people don't place the machines. The legislature would determine it. The Kansas Gaming Commission would issue They buy the machines and issue them, and all of the things that you all have talked about, all of these legal triggers that we are trying to interpret legislative initiatives, we're trying to interpret legal initiatives, legal opinions. That's not in our jurisdiction. I would say that attorneys at the Topeka and attorneys at your office show up every day and work on everything that they work on. If some days may be slower than others. But with that said, the new information that's come out, this thing has been talked about for 10 years, and it's still got the monopoly that the state and the casinos have for 25 years is truly a monopoly of gambling in the casino business. This is pari-mutuel that was around before that happened. This would allow electronic gaming machines, not casino stuff, at a pari-mutuel facility. The new information that came in is that when I was approached, or a couple of us were approached by, is this possible? All of this discussion that happens off and on around the community, pro and con and whatever, mainly pro because 80% of the revenue at the Kansas Star Casino is from Sedgwick County people. And so it was determined that the owners of the Greyhound Park would, because now they own the land, they bought it, and that they would conduct a independent poll, a survey poll, basically by a polling company, not even a local polling company, an independent, out-of-state polling company. And that poll was conducted, and ironically, the second question, do you think the voters of Sedgwick County should or should not be allowed to vote on this issue to put electronic gaming machines be allowed at Wichita Greyhound Park? And the response was 78% definitely should vote and 13% probably should vote. That's 91% of the public, just on that question, wants to vote on this issue. So with that information and ironically, and then it says, would you vote yes or no? And obviously there's a majority say yes, not quite that. But the irony is that would you vote yes or no? 25% of the people said they would vote against it. But that same 25%, that 91% still say they want to vote. The citizens want to vote. That's plain and simple. That's all that we are promoting is if 91% of citizens want to vote, let them vote. I'm personally I don't do slot machines. I'm not a big fan of them. But I don't care. It's 91%. The other irony, which we just had a presentation earlier, this wasn't set up. It's ironic. This is great information. If it passed, it's estimated that about $2 million a year would come to Sedgwick County as part of the license stuff. How would you prefer this money be spent? Well, the majority of the people, or 36%, the top thing was for mental health programs. So there would be a funding stream to fund exactly what we had a presentation on that would be on in perpetuity. And then after that, it was roads or public safety, whatever. So we, as a commission, could dedicate a funding source to that. How often do you visit a casino? Very seldom, 37, never 30. 67% of the people that responded to this poll never go to a casino. So again, with that information in hand, the demographics were all over. They were equal distribution in our county districts, majority Wichita, less majority outside Wichita, age, Republican, Democrat, income. It was all nearly 90%. So with that information, That's why myself and felt comfortable asking for this to go forward. It's simply a vote and allowing the people to vote. And it's all of the other information is great dialogue for legal opinions and what ifs and what ifs and how much is the penalty or not. That can be determined. And if the vote's determined to be not valid, it's determined to be not valid. But at this point, then so be it. So with that, we could have a little more dialogue, but I wanted to just share some of that. By the way, the public information, if we want to worry about Kansas Star Casino, last month they brought in their total revenue was $15,450,000, of which the state got 3.399. 3.4 million goes to the state just on Kansas Star, which is the largest casino by far of the other three. But they're a casino. Again, we're talking about a pari-mutuel facility. The Kansas Star does not do pari-mutuel wagering. And they made reference to the 2,800 gaming machines available in pari-mutuel facilities. So I know we're having a lot of emotion about it, but that explains a lot. And this poll is what it is. So
I have a question. So speaking to, so let's say hypothetically that we do vote on this and it passes, then it goes to the legislature. And so for the past 10 years, they have been lobbied for this, and it's not obviously come to fruition because we're here today. So that's essentially what we're doing. So would it behoove us to, if there is the will, to put this on a legislative platform and go that route, since it's going to go to them anyway?
I can speak to that because I was on the phone earlier this morning with the majority leader of the Kansas House. He thinks it's imperative that we do it in this, that this be the strategy. So in this order, one of the issues they've continued to have up in Topeka over the last decade is, well, Sedgwick County voted against it, so therefore why are we going to take this up if the will of Sedgwick County is not there? A lot of people might not. I actually worked for the No Casino group, so I was anti-gaming in 2007. I was a field staffer, paid staffer to stop the casino. So, because I'm not, I don't believe in gambling, but I do believe in allowing people the right to vote. There were 101,000 votes cast, a little over 101,000 votes cast. The dog track failed by 246. So when we think about recounts and stuff, I mean, we're talking a fraction of a percent. 246 votes out of 101,600, roughly. And a lot's changed since then. We have gaming in our region. Anybody that thinks that we don't have casinos in Sedgwick County, I think is living in a false reality, because even as you go to Kansas Star Casino, that off-ramp, you will be in Sedgwick County still as you approach Kansas Star Casino. So it's in our region. 80% of that $15 million that Commissioner Mindstrom was talking about comes from Sedgwick County. And not just that, it's had a complete adverse effect on Century 2 and on conventions in Sedgwick County. And I'm sure the city of Wichita can provide that information. So it's cost our community a lot. And this vote that we're discussing, if we put it on and something happens and it gets, pushed off, it at least sends the message to the legislature that this is a discussion we need to have. And both in the House and the Senate, they believe that this would be the right steps. And some of these people were there in 2006 when this passed that believe that this allows the opportunity for another vote. But we don't know what will happen with the courts and with lawsuits. But as far as sending a message to the legislature, this removes the number one obstacle, which is it got voted down in 2007 but the casino failed by about 10 points. So this was kind of it was a down ballot drag that when people were just voting no, they voted no twice, even though the main goal, like our goal for no casinos in Sedgwick County was to stop a casino in Sedgwick County. We didn't really discuss the slots near as much. It was more about stopping a casino. And so that's my thought on this. I believe that I trust the voters of Sedgwick County. I trust the voters in my district. And there's nothing that prohibits us from putting this on the ballot because it is a binding vote. So I say the most democratic thing we can do is allow a vote. That's my opinion.
Thank you.
Mr. Chairman, I have a few more comments. Again, I understand we're going to debate whether this is a binding or non-binding resolution. I don't see that there's an action that happens as a result of this vote. We're not doing something other than just telling the legislature the new opinion of Sedgwick County. So because there's no actual action, any action that would happen is a consequence of the legislature itself, not the county. So in my opinion, this is still a non-binding vote. And again, maybe that'll be debated in the courts as well. I guess we'll find out. But I do support, having the electorate vote. I love that. I'm a huge fan of having people vote. The challenge in this case, in fact, I've not seen that poll. I would love to have a copy of it. But one of the things about this is if you ask them to give their opinion once they understand the risk, the liability, the taxpayer dollars that are at risk, and knowing that this is not necessarily as simple as it sounds. We're not just adding a new opportunity in Sedgwick County, but we're actually putting ourselves at risk of lawsuits. And that's really the major issue here. I think we have to know that, and the people, when they vote, need to know that they're actually willing to go down a path that says we're going to put taxpayer dollars at risk. And without that information, then to me, the question is not very useful as it was read to us just today. But that's why I think the legislature should act before us to find out, let them figure out what our risks and liabilities are. Once they determine we can go forward, I have no problem having this on the ballot.
But then do you support us asking the legislature to do this?
We can do that ourselves.
Right. So you support that?
I support us asking the legislature, that's fine,
To put it
to address the issue, to find out what our risks and liabilities are as a county if this was to go on the ballot. And let them, if you will, grease that path. But the reality is if we do this first, I think we just have lots of legal risk to do this. And finally, that estimate of $2 million of new revenue to Sedgwick County, I'd love to know how that was calculated, because I understand we get 1% from Kansas Star. You mentioned a minute ago $15 million this month. I've gone back and checked. We've had the casino in Kansas Star has reported anywhere between $15 and $18 million a month. The county has received just this month, I believe, $156,000. Last couple months ago, $163,000, $150 before that, $185 before that. So we're getting 1% of the revenue from Kansas Star. And I understand if this was to go to Greyhound Park, two things would happen. Number one, I think you'd see the activities of our community would shift from Kansas Star to the Greyhound Park. This is not, and one of the arguments is this new gambling or just a changing where the gambling happens? That's a great question. There's arguments, I think, that people would like to say maybe some of both. But the reality is I think Kansas Star would have less revenue potentially, which has an impact on Mulvane and Derby especially, and jobs down that way. Park City would probably see some jobs potentially, but I understand as it sits right now, it would be a 2% share to the county, but I had no doubt whatsoever that Park City would annex this property, changing it back to 1%. So if there's no more gaming happening in Sedgwick County, you're just changing the location, there's actually no benefit to Sedgwick County. But we do accept the risk.
That's a broad assumption.
We don't know. But
do you know that I've had discussions with Park City and explained specifically their concerns as well about the mental health issues, and that if they would annex this, would they be willing to negotiate that percentage so we could put it towards mental health? Okay. And they said they were very open to that. So you're saying stuff in making broad assumptions and legal assumptions, and you're not an attorney.
You're right.
and you're not.
Commissioner Meitzner, with all due respect, this has been the argument for many, many years. I didn't make this up. And whether
that's
this
a great
is legitimate
argument.
or not, I don't know. I'm just simply saying
Yeah.
it is
You're
possible
saying
they
it-
would annex the
You're saying it
property.
like it's legitimate.
And if it would,
Now you're saying legitimate or not. So you're correct. Is it legitimate or not?
if they
So
annex the
don't-
property, it changes it to 1% by law, unless they want to renegotiate it, which is new information, okay? But it does, they have the right to, they have all the cards in their hand.
Okay.
If they want to annex the property, it changes it to 1% to the Sedgwick County.
And how much property tax is paid today on that property that's vacant? About 10,000, 15,000 a year.
Okay.
So even if it comes on the payroll, if they build a $300 million operation, that goes to about 300,000 to the city or to the county, 250,000 to the Park City, school district, whatever. Or, so you're splitting up $1 million a year or splitting up 15,000 today.
All right.
So that, and the 300 jobs is real because when they closed the casino, or the dog track, which they regret that they had to do that, they laid off 350 people that day.
Did they have to do that?
They closed it.
I know they did,
350
but-
people were
but the question is,
employed, so they.
The law
they
did not
closed-
cause that to happen. That was a decision by the people who owned and operated that operation.
Right.
They made a choice.
And they said that they would reopen it and immediately hire 350 people. Because it had extended hours, because there'd be more than pari-mutuel going on in various sessions. There'd be electronic gaming machines going at very extended hours.
Anyway, I just want to share my concerns, and to the extent this is a non-binding vote, that's my opinion, is this is non-binding. And so I think we have many legal risks to do this. And if the legislature would act first, then by all means, let's stick this on the ballot. I would support that totally.
But we'd have to ask them to do that. They're not going to do that on their
I
own.
want them to address all the legal aspects of this and and grease the path before we go down this road. That's all.
They won't do it unless we ask them.
Well, a couple of things. One, I do not believe what is going on our agenda tomorrow is a non-binding vote. It looked to me when I read the documentation that was provided to us that it is a binding vote that says we'll conduct an election and we'll present that information. So I don't think it's a non-binding vote, first of all. Second of all, asking the legislature, I don't have a problem if we want to send a letter up to the legislature and have them if they want to review it. I have a significant problem if we put it on our legislative agenda. And the reason for that is last year we put on our legislative agenda daylight savings time, and it sucked all of the air out of the room. That one issue, all of the air. Our number one issue last year was behavioral health, also transportation issues. Did we get anywhere with that? Absolutely not, because every single thing that was ever reported was daylight savings time. So if we put this on our agenda, we might as well just put that down and forget everything else, because nothing else will happen, because everybody will be focused on one issue. So
Can I ask, is it possible to do a special resolution to clarify this as a separate item now or in the next 30 days and get it up in front of the legislator? Can we do a resolution that would specifically?
Commissioner Meissner, certainly we could draft a resolution. It would be non-binding, but it would be a resolution directing to the legislature whatever the will of the Board of County Commissioners would be. And we could prepare that and do that. And that separate and apart from the legislative platform, as the chairman just mentioned.
Didn't mean to interrupt.
no problem. I appreciate any ideas where we can get our things that are important to Sedgwick County before the legislature. Problem is when we add things that take away the really critical issues, then I have a concern. And our real critical issue, as we just heard first thing this morning, is behavioral health. And
how to pay for it.
We need the legislature to figure out how that we can pay for things like a regional mental health facility. So I don't want to do something that's going to jeopardize our legislative agenda either.
I hear you.
That's fair.
One other comment, if the poll was done by a third party, I think the poll speaks for itself. It doesn't necessarily address the legal concerns, but I trust the legislature to consider those things anyway. You could provide a copy of that poll and make the same argument, excuse me, make the same arguments that the opinions of Sedgwick County may have changed since 2007. I'm sure they probably have. And I think that poll probably, makes that very clear. That should be enough justification for them to have a discussion.
But how do we do that without making that part of our legislative platform?
I think we can send a letter up signed by all 5 commissioners and ask them to review it. But if we put this, I do not believe we're going the right direction right now, putting this on our meeting for tomorrow to discuss this and put it before a vote that I think is going to get us sued.
One other thing about...
Doesn't seem to be any good options then.
So can I ask a question? So we can conduct an election. I mean, I just feel like this is kind of rushed. I have a lot of questions that I'm trying to... So the reason we're doing this is to get it on the ballot in November, but if, say, whatever happens, we could conduct an election at any time. Is that correct?
But doesn't it cost us a substantial amount of money?
This is probably a question more adequately addressed to Tabitha, our election commissioner. Just to give us a general idea of how much maybe a mail, I'm assuming we're probably, if we're going to do a home rule election, it's probably going to be a mail ballot election. And I don't know, I've heard in the past those run around $70,000 when to conduct an election like that. But
Tabitha, could you go to the microphone? Thank you.
Whether or not the election would be mail ballot or not would be at your discretion. Mail ballot would be, because of the number of registered voters, would be significantly more expensive to do. I know the special congressional election that we had in 2017 was a little over 200,000, and we would expect actually higher turnout on this election than we saw in that one. So it would be more than 200,000. Is that all the questions that there were that you needed from me?
Is there an option other than a mailing ballot?
Yeah, you can do a polling place, but the one in 17 was a polling place election.
How much would a polling place special election cost?
More than 200,000.
And a mail-in ballot would be more than 200,000.
Significantly more, because you're actually paying the postage. When you do a mail-in ballot election, you have to pay the postage out and you have to pay the postage return, because it's the only way for the person to cast their ballot. So by law, you would have to pay return postage as well as outgoing, and that cost adds up pretty quickly for 300,000+ people.
Thank you, Tabitha.
So I think maybe Commissioner Cruz to answer, I guess it could, if we got to a point where we approved a ballot election on an issue like this, we would want to put it on some kind of future election. That's doesn't cost anything, right, Tabitha, to add a, I know. So my question is the cost of adding a ballot vote on a regular.
Right. The cost of actually adding a question, say, to November election is negligible. Right. However, the difference in turnout for that election versus, we planned for, last mayoral election saw 16% voter turnout. This special election in 2007 for this saw 44% turnout. We would have an increase of cost to cover the expected increase in turnout. Would not be the 200,000 of having a standalone election, but we would have to plan for an increase in voter turnout, because the only data we have is from 2007, and there was significantly higher turnout. If you're talking putting it on a ballot next year, the cost would be not so much in turnout, but it would might force us to go to 2 ballots for every 1 voter. And that would be incredibly expensive for us to do. It just depends upon how many other questions we end up on the ballot from potential everybody else. So there's a lot of things that factor into how much it would cost next year. Sorry, I can't give a better answer on that.
But don't we still have to consider disorderly conduct of an election on whether or not we put it on a ballot?
That's the question that I have, is whether or not this is an advisory election or whether it's a binding election. That has to be answered. And if you call this, that will be answered probably. I've got my independent counsel that I have not gotten to meet with in depth yet, that I have to talk to on this. But at this point, if I'm told this is legal, you can do it, I have no problem. If I'm told this is an advisory election, then I can't put it on the ballot this November. And so I don't know yet how to do that until I've met with everybody involved and made a decision.
The more lawyers that we're going to be paying to figure this out. Thank you. But it makes Mr. Papoon happy.
I may make our profession happy, but I'm not particularly
Keeps lawyers fully employed.
Yeah.
So one thing that we haven't talked about, I have received a plethora of emails over the past, listen, I am all for letting people vote. I want everyone to know that I am for that. But one thing that I have been receiving a ton of emails about is the dog racing and animal rights activists. So I want to just broach that subject with everybody, because I think that is something to be considered, because that's essentially what we're talking about. So when I am a representative of 100,000 people, and essentially 500,000 people when it comes down to Sedgwick County as a whole, what do I tell those folks? How do I represent those folks who are concerned with that aspect of this parimutuel gaming facility? That's my question. I mean, because that's a real...
Well, it's a state, again, it's a state authorized. Parimutuel is determined statewide, right? I mean, it's a state issue. If
Mr. Chairman, can we have some data researched and brought to us? So I think this is changing nationally. Someone contacted me and said that 41 states have banned dog racing in their states. It's a kind of a dying thing, and I understand that for this to happen at all, that dog racing must be part of this mix, at least until 2032, maybe even beyond. I don't know what happens in 2032, but dog racing, and have to do a certain number of races per day and that type of thing. So I guess I'd like to know, can we have someone validate some of those data points, whether or not 41 states have banned this, and what's the requirement for dog racing at the site if this was to happen?
Thank you. And I agree with Commissioner Cruz. I've gotten the same type emails that you've received, where that there are a lot of people that are very concerned about the Greyhound Park having dog racing involved again.
Yeah, and I know like Florida recently banned it last year on the ballot, but there's lots of states they have virtual dog racing, so facilities will have it streamed from places like Arkansas or Iowa. There's simulated, Kansas Lottery does simulated horse racing every day. So there are ways, 21st century ways around it that the legislature can address and see what's allowed, whether that be simulcast or digital.
Do we know what it would be? I mean,
it's up to the legislature and the Kansas Gaming Racing Commission, which approves everything. We can't approve any of this stuff.
So they could have dog racing today.
Sure.
They just don't.
Exactly.
Okay.
Any other comments today?
I appreciate the discussion. Thank you, Chairman.
Very good. Well, it looks like we're going to have more discussion tomorrow. I was hoping that we could decide not to put it on the agenda tomorrow, but it doesn't sound like that's an option at this point. So we will be back at the bench tomorrow to discuss this. Mr. Manager, anything else need to come before the Commission today? Very good. Any staff have anything today? Mr. Spears.
I hate to bring this up, it seems minor to everybody in there after what we've been talking about today, but it's major to us now as public works because it's part of our road right-of-way responsibility. But tomorrow on the agenda on bid board is what's called 2 boom boards. And I know we talked about that last Friday, and I thought about it over the weekend a lot. A boom mower, what it does is it can mow a slope that a regular mower can't mow, so it's an important item. It does have a dual function that we did not talk about. What it also does is it's a deck, and it flips up like that, and it can trim trees.
Tear the heck out of trees.
We have a lot of hedgerows in Sedgwick County. Very important to trim those trees. I know Mr. Howell down in your district, not us, but Sherman Township, as you and I have seen, it can be a big problem. Okay, so these boom mowers we're wanting the low bid. We're not wanting the high bid. The low bid meets the spec. It's low by $65,000. The ones we have two now. We could use 4, but we only have 2. They're worn out and had them for about over 10 years. We also can use those when it's wet out. You know, your regular tractors, you go down into the ditch. When you go down into the ditch, you lose, you make ruts. So the boom mower can reach out and mow our regular areas when it's wet, and we do get calls on that. Also, you know, down south of McConnell, we mowed those reeds that were coming up out of the wetlands type area. So have a lot of uses. The other thing I want to point out is that's trimming the trees. We can do that in the wintertime, and we can keep our folks busy doing that in the winter. And I think that's an important point because we're, you know, always looking to keep everybody busy, especially in the cold weather. So let's see. I think that's about all my notes. The price, okay, it's $360,000. But you figure if you use that 10 years, that's what, $36,000 a year. So 12 months, that's $3,000 a month for 2. These is 2 mowers. So it's $1,500 a month per mower. If you keep it 10 years, knowing the county, we usually keep everything as long as we can. And so if you went out to rent one of these, we found one over the weekend that was over $7,000 a month. So I think it's a good investment. I think if one thing we did years ago, we didn't have these, and this is what started this. We didn't have any equipment, so to trim trees, we went out with a backhoe and we ripped the limbs off of them. You just rip them off, and it looks terrible. There was a lot of calls into commissioners, and that's why one of the reasons why we went to the boom mower. So I just wanted to make that pitch today, and
well, I appreciate that, and you're always judicious, and you're always very careful about what you choose to invest in or not. And I know I appreciate that, and take your advice on it. And your crew, you know what they need. So I'm supportive of that, David.
Have you looked at contracting?
No, we have not yet. You know, you and I talked at the end of the day Friday. I know you mentioned it and wanted to know, you know, the different locations. And I don't have a list of but we use it a lot of places. And then we had not talked about, I forgot to mention that we trim the tree. So that's a huge deal with it. And I was thinking that would probably change your mind anyway.
But I've seen some of the trees have been trimmed with this, and they are tore to heck too.
Not as bad as ripping them off with a backhoe, though.
No.
I can guarantee you.
Very good. All right. Any other staff have anything today? What about any of our electeds? No? All right. Let's go to work.
I didn't hear that.